All right, here's the thing. I was thinking about conflicts of interest today, and I was thinking, what is a conflict of interest? That's what I was thinking. Now, you all know the term conflicts of interest, right? Is there anybody here that's willing to admit they've never heard of a conflict of interest? So what is it? We all know what it is. What is it? Anybody brave enough to hazard a guess? Yes, sir.
Conflicting loyalties.
To who?
Several people to whom you owe a duty.
What duty?
A duty, well, supposedly fiduciary duty to represent them.
Okay.
Zealously in their best interest.
No duty in California to represent zealously. In some jurisdictions, you're just supposed to represent them well. That's not a bad definition, I don't think. But let me ask you this. Is that a complete definition? Are you done? Is that your final answer?
That's my final limited answer. As best I recall at this time.
I've been here about 45 seconds. I've already forgot to repeat one question. Okay. Anybody else with another definition, or they think that the definition that was just given isn't complete or broad enough? All right. Let me ask you this. A law firm, because I have this hypothetical. This hypothetical out there is something I'm involved in right now as we speak. A law firm is hired to represent 7 defendants in a case. And one of the defendants is them. They have a conflict of interest? Yes. Why? What if it was only them and one other defendant? There wouldn't be any competing loyalties, would there? Yes, nods don't get picked up well on the camera. What are the competing interests there?
The settlement is something else.
But whose interests are competing?
The law firms and the other defendants.
Yeah, so the law firm's own interests causing a conflict there, not just the interests of other people. Conflicts of interest is a term that's used all the time. You could barely ever open up a daily journal or recorder and find a day when the term isn't used in the context of a disqualification motion or a legal malpractice case or something else. But it's a poorly defined term. In fact, it's an undefined term. If you look in the ethics rules from which conflicts of interest are supposed to come, nobody defines it. We'll talk about that too. Here's a definition that I would give. And then we're going to talk in more narrow fashion. I think a conflict of interest, and I hate that term because it isn't really interest, but I think a conflict of interest exists anytime a lawyer's duty to his or her current client is impeded by anything. And that would be the interest of another current client. That's what most people think of as conflicts of interest. The interest of a former client. That's also a conflict of interest. The lawyer's own interest. That's also a conflict of interest. Even a third party. If the lawyer has some kind of loyalty or duty or interest in advancing the interests of a third party, that might chill the lawyer's ability to advance the interests of a current client. In any case where the lawyer's duty of loyalty to a current client might be impeded, that lawyer has a conflict of interest. Now, let's talk about that in more detail, because now we're talking about a very broad spectrum of things. There are different types of conflicts, as we just said. One of them are conflicts that just involve conflicting interests of current clients. Those are usually all jumbled together. Legal ethicists and the rules and everything don't really differentiate very well, but we're going to differentiate today. I think that one term that's used for this type of conflict might be better than others, and that's open file conflicts. You have an open file conflict when the interests of current clients are thank you, contrary. But there's more than one type of open file conflict or current client conflict. The one that's most common, and maybe the one that we'll spend the most time on today, is the conflict that arises in the situation I've already mentioned, where the lawyer represents more than one client at the same time. That's called a dual representation conflict, sometimes called a multiple representation conflict. It has other names as well. I'll call it a multiple representation conflict. There's another very different type of open file conflict, And that's when the lawyer is simultaneously representing two different clients, but not in the same manner. And the interests of those two clients may be adverse. That could be a conflict too. Why would that be? A lawyer owes a current client what? You've already alluded to it. An absolute duty of loyalty. A fiduciary duty. Some people say a quasi-fiduciary duty when they're trying to get out of it. But it's really a fiduciary duty akin to that of a trustee. A lawyer owes a duty to a current client to do what? To basically not do anything that's adverse to the interests of that client. And so it isn't just enough to say that I'm not going to actually do something negative towards this client in the case I'm representing him. You can't do anything that's adverse to the client, just like you wouldn't do anything adverse to the interests of your spouse or your brother, even if it's another unrelated matter, completely unrelated to anything that you're working for the client on. You're not allowed to do anything adverse to the interests of that client. Multiple representation conflicts. This is the type most people confront in their practice more of the time. A multiple representation conflict issue arises when? I almost heard something. That's exactly right. A multiple representation conflict arises every time a lawyer has more than one client, simultaneously represents more than one client, vis-a-vis the same matter. Every time. In California, well, let me back up a second and say this. I don't know how many lawyers there are here or anywhere that have never represented more than one client at the same time. If you do estate work, you might represent the husband and wife. If you do real estate work, God forbid, you might represent the buyer and seller. In almost any type of work, the example I like to give is the entertainment law practice, this area that's rife with conflicts. It's very funny, entertainment law practice. Anybody entertainment law practitioners here? Probably not. Wrong venue for that. But entertainment lawyers tend to not meet any conflicts they don't like. It's conflicts of interest that allow them to sell themselves. Anyway, never mind. You're not entertainment lawyers. You don't want to know. Here's the point. 4 people come into your office. They're members of a group. We'll just give them imaginary names. We'll call them John, Paul, Richard, and Jimmy. And they're members of the new group, and they come in with their manager, and they have a big deal that they're about to sign, and they want you to be their lawyer and represent them. Do you have a problem? Yes, you have many problems. You don't just have one problem. You've got lots of problems. Well, at first it may seem like you don't because they're a group, and all their interests are aligned. You're representing a group. They all have the same interest in getting the best recording deal. But the thing is, as it turns out, as you get more facts from these prospective clients, 2 of them, Paul and John, seem to be the ones that write most of the songs. They're also the ones that, seem to be leading the group. Do they have any different interests possibly than Jimmy and Richard? They might have differences in terms of royalty agreements. There might be all sorts of different things. How are you going to represent them all simultaneously? And then what about the manager who comes in with them at the same time? Does he or she have the same interests as the members of the group? In some ways, yes. In some ways, multiple clients are aligned, but in other ways, they're not aligned. So what do you do in that situation? Most lawyers say, oh, that's no problem. I love this. That's no problem. Because, first of all, I don't think I have a conflict of interest. That's the first thing, because their interests are all the same. But assuming there's a theoretical potential conflict of interest, they can waive it. Sign here, problem goes away. That's basically what people think, or a lot of people think. Some people here obviously don't think that. There's several problems with that logic. The first thing is, you do have a conflict of interest, because what I started to say before is, California doesn't distinguish between actual and potential conflicts of interest. If you have a potential conflict of interest, you have a conflict of interest. And you have to go through the exact same dotting of the I's and crossing the T's as you would if you had an actual conflict of interest, right? So you do have a conflict of interest. The second thing is, this concept of waiver really pisses me off because that's not what the law says. There's nothing in the law or the ethics rules that say get a waiver and you're okay. What the ethics rules in California say, and what the case law says, sometimes you can represent clients, multiple clients, even though there's a potential for conflict between them, if you get their informed consent. So you have these lawyers who go, okay, I got them to sign a waiver, I'm home free. They put it in their breast pocket, and that's the end of it. To me, that's just plain funny. Because years ago, I had this case, just anecdotal, but it'll give you the idea, where my client was an insurance company, and they wanted to move to disqualify this law firm who was representing two other clients. Standing issues aside, which I don't think the other side ever thought to raise, the firm goes, we've got no problem because we have a waiver from both of our clients to represent both of their interests. Well, we knew there could be some problems. We knew there could be a waiver, so we tried to get them to produce it, but they said, no, we're not going to produce it. Forced us to file a motion to disqualify. And then, of course, in their opposition, they slam down on the table the waiver. And they say, we got a waiver. You lose, and not only do you lose, but insurance company, you're even more in bad faith than we thought you were before. Well, the problem with that logic, as we were able to convince the judge, is a waiver, a written waiver, doesn't necessarily establish that you have the informed consent of your client. In fact, it can establish the fact that you didn't. And this one did just that. Because why? These waivers are obtained at the outset of representation, at a time when it's very difficult, often, to know what the conflicts are going to be. Even if you can envision a potential for conflict, you can't envision necessarily how all the facts are going to play out, how it's going to actualize. And so, what they're signing at the outset of representation may not really reflect the conflict that arises later on down the line. And so there's case law out there that says, well, yeah, you can get a conflict waiver at the outset of representation, but every time there's a change in the conflict's landscape, you got to get a new conflict waiver. So far, hang on one second, I'll take that question in a second. I never meet lawyers that get new waivers. It doesn't work like that, especially big firms, my favorite targets for everything. They do their new client memo at the outset of representation. They plug the data into the computer. Their non-lawyer, mostly computer personnel, decide whether there's a conflict. They tell the firm yay or nay or whatever. They get a conflict waiver, whatever, and then that's it. And then 6 months later, a year later, 2 years later, when the conflict's landscape changes, when a potential conflict actualizes, when something that nobody realized was a conflict at the time appears, or when the facts just change, like the client merges